welcome to Zoom with Czarny. I'm Dustin Czarny, Democratic Elections Commissioner for Onondaga County, and this is my interview show. Back after a 1-month hiatus as we took a little break because we were in the primary election, but we're back with Professor Thomas Keck. He's been on probably my most frequent guest. He's been on the program a lot, dealing with the Syracuse, or he's the Syracuse most leading expert in the Supreme Court. And boy, what a doozy of a term we had. We outlined all of the cases that were released at the end there, including the immunity case. And also we talk a little bit about Eileen Cannon's ruling in the documents case as well. He's an incredible expert. It's such a pleasure to have him on, and I can't wait for you to see that interview. This week I am off. Well, not off. I'm traveling to Minneapolis. In fact, I'm still there today, if this goes up on Friday like planned. And I'm at the Partnership for Large Election Jurisdictions conference. I'll go into that a little bit next week in my commissioner in a car. But these national conferences I've had the honor of being a part of. I'm representing New York and Onondaga County, and the large election jurisdictions. Those are election jurisdictions with 300,000 more population, which of course Onondaga County falls into. So it's a great conference. I can't wait to share with you what I learned in that. But for now, please stay tuned for my interview with Professor Thomas Keck. And we're back, and I'm very happy to have, well, I am happy to have him on, but it's not ever really seems to be a happy occasion when he comes on. But I have our friend Tom Keck, who's probably the most frequent guest of Zoom with Czarny. He's SU professor, one of our local experts on the Supreme Court, and has really been coming on quite frequently since we got this 6-3 super conservative majority back in 2020. Professor Keck, thank you so much for coming on Zoom with Czarny again.
Glad to be here. Thanks for having me.
So it's been a term. We checked in at the beginning of April, when the Trump ballot case was released, and we said, well, we'll check back in July and see what else fresh hell is brought to us. And I think I'm consider myself very naive still, apparently, because I really did not think that that the court would come down in the way it did on the Trump immunity case. And there's other cases we're going to talk about too. But why don't we just dive right into that? Because I think that's the that's the news of the day, and the most consequential case of the term. And it came on, it didn't even wait till the end of June. It went into July to get that case. Your initial reaction, Professor Keck?
Yeah, Dustin, I mean, I don't think you're the only one who's feeling like, wait, I was like a little bit naive. Even those of us who have been quite sharply critical of the current court still have always sort of held on to, well, yes, the current court has, moved quite sharply to the right, and they overturned Roe versus Wade, and they've done lots of stuff that is new and seemingly quite dramatic and extreme, but still there were it was like a mixed bag, right? Like there were other cases where Roberts or Amy Coney Barrett or Kavanaugh or whoever it might be would join with the more liberal justices for a more kind of middle of the road opinion, trying to keep the court kind of operating sort of like a court, not just like an arm of the Republican Party. Like there's I think lots of lawyers and people who study the court, and for sure, like politicians, right, members of Congress, Democratic members of Congress, there's a very, very strong investment in the idea of the court. And so even though it's like doing 1, 2, 3, 4, 5, 6 things that we think are profoundly wrong, still, as long as some of the time it seems like it's acting more like a neutral court, folks have been very reluctant to sort of kind of give up on the dream or whatever. And so, and if you go back to January, I don't remember exactly what we talked about in April, like how we framed it exactly, but I know I just went back and looked at something that I wrote in January. And so it was, none of these cases had been decided yet. And the talk at the time was that the court had agreed to hear the case about Trump's eligibility for the ballot out of Colorado, and it had agreed to hear this immunity case, and neither one of them had been argued and decided yet. And lots and lots and lots of people were saying at the time, well, okay, this is a great opportunity for the court because we don't think they're going to kick Trump off the ballot. That would be quite surprising if they did that. But we also think Trump's arguments for complete and absolute immunity are completely, a reach and over the top. And so we don't think they're going to do that either. So it's a nice opportunity to rule in favor of Trump on one thing and against Trump on another. And that's kind of maybe how we think a neutral court should operate. But that's not what they did. They ruled in favor of him on both of them, right? And so it really, I think, has, it's not the first instance of this. There's been repeated instances, but kind of like lifting the blinders for people. And we really do have to face the fact that the current Supreme Court is just repeatedly issuing rulings that benefit Donald Trump's Republican Party, and this is the most direct example of it. So that's a lot of preface, and we can talk about the specific case now too.
Yeah.
I think most of your listeners probably are familiar with the gist of it. So this came down back on July 1st. And it's, there's multiple ongoing legal proceedings involving former President Trump. This is the prosecution by Special Counsel Jack Smith in Washington, D.C. It's in many ways the most significant of the cases against Trump. It's directly implicating him in what is essentially a coup, an attempted coup to overturn the results of the 2020 elections. And there's lots of detail in the indictment about all the various actions that Trump took in conjunction with Justice Department officials and in conjunction with state legislators and in conjunction with Vice President Pence and in conjunction with the mob on January 6th to try to prevent the certification of Joe Biden's victory in the 2020 election. Many of those actions are clearly illegal, right? And so Trump's finally going to get held to account for some of his most egregious crimes, is what lots of us have been hoping. But Trump's lawyers argued in what was widely described as a long shot legal argument, the goal of which was primarily just to delay the proceedings, right? That's how this argument was characterized by lots of people. He argued that the president is completely immune, former president is completely immune from criminal prosecution for any actions taken while he was in office. A DC trial judge rejected that. The DC Circuit panel rejected that. And then, of course, he appealed to the Supreme Court. They slow walked their decision. They kept it for the last day of the term, which already is a victory for Trump, right? Because it delays any further proceedings.
And on that, not only did they slow walk their position, but Special Counsel Jack Smith asked them to visit this and expedite it even before they decided to take it up. It was back in December when, even before the appellate court in DC heard it, the federal appeals court heard it, he wanted the Supreme Court to expedite it then, because I think we all thought it was a slam dunk position. Of course the president isn't immune to the laws of our nation, but that, at least that we would get an answer earlier and the trial could go forward. And the Supreme Court decided not to hear it then, waited for the appellate court, which also took its sweet time in making the decision. And now here we are in July with this immunity decision, and it was a 6-3 decision for most, 5-4 in part, but let's talk about the decision itself. I think that's important, because it also led to, I think, today, we're recording this on Monday, today's decision by Judge Eileen Callan on the it's not just about the insurrection case, it's about the the classified documents case, because now she's thrown out that that ruling based on, in part, on a concurrence by Justice Thomas here. So the Supreme Court majority 6-3 ruled that the president is immune from totally immune on his official acts, and then also probably immune on any non-official acts, or at least it's
So
it's
let me jump in there,
yeah.
because that's not quite right.
Okay, all
So
right. Yes, please.
so the court basically divides presidential acts into three categories, and they say and three different rules apply to the three categories. And so they say for official acts that the constitutional text explicitly assigns to the president alone. So think like the pardon power, right? The president is completely immune from criminal prosecution. So the constitutional text very clearly says that the president and president alone has the power to issue federal pardons. That's entirely up to him. You can't prosecute him for that under any circumstances. So that's the first category. Second category is official acts taken by the president under his powers, but where the constitutional text is sort of more ambiguous or mixed as to sort of who's responsible for this set of government powers, right? So there's a lot of things that the Constitution sort of assigns as shared powers, right? So the president is commander-in-chief of the Army and Navy, but Congress has the power to declare war. Congress has the power to pass laws governing the armed forces, right? So that's a shared power. And so for that category, the court said the president's actions are presumptively immune from criminal prosecution. And so you could still potentially prosecute him, but you would have to convince the judge. You'd have to have an extra special convincing argument for the trial judge to get them to allow that indictment, that part of the indictment, to go forward. And then the third category is unofficial acts, right? So if the president is walking down the street and shoots somebody on Fifth Avenue or whatever, that's not an action as president, right? And so the court says the president is not immune for those acts, but there's a but, right?
Right, there's a but.
There's a but. The court says the president is not immune for unofficial acts, which they have to say, because the constitutional text itself and lots of founding era documents refer to potential prosecutions of former presidents. So they know it can't be complete absolute immunity for everything. And so they say, yes, for certain non-official acts, a former president taken while he was in office, a former president can be criminally indicted. But the big but is that in an effort to prove beyond a reasonable doubt to a jury that the president committed those criminal activities, you cannot use evidence about the president's motives or about his official acts, right? So the things that he's immune for, you can't indict him for those things, but you also can't discuss those things in an effort to prove his conduct for the things that he is not immune for.
And
so
that's the part of the ruling that Amy Coney Barrett left the majority and joined the minority. The three liberal judges, so she joined with them in dissent of that particular part of the ruling. Is that correct?
Correct. Yeah, she disagreed with the majority on a couple particular points, but that's the most significant one, is that she said if you're prosecuting him for unofficial acts, for sure the prosecutors can still discuss his official acts if they're directly relevant. The example that she gave is if a president is indicted for bribery, right? So then there's a quid pro quo, right? Obviously, the lawyers are going to want to introduce evidence about the quid and the quo, right? What was offered to him? That's somebody offered him a bag of cash or whatever. And what did he do in exchange? Well, did he issue a pardon, or did he agree to sign or veto a law or whatever they wanted him to do? That would be an exercise of an official power, but they're not prosecuting him for exercising his pardon power. They're prosecuting him for accepting a bribe. But if the thing that he offered in exchange for the bribe was a pardon, then of course the prosecutors should be able to talk about that in court. And Chief Justice Roberts said no. He responded to her argument. He tried to draw some fine distinctions. He says, we're not saying you can't mention it at all. So the nuances are still to be worked out a little bit, but it seems to create an awful lot of hurdles to successfully prosecuting a former president for conduct committed while they were in office.
And we're going to get to Justice Thomas's concurrence, which led to the Eileen Cannon debacle that happened today. But let's dial in on what this ruling means for the insurrection trial. It's not over. They didn't throw it out, but they have sent it back to Judge Chutkan to do an evidentiary hearing, which of course is going to delay this probably already delayed trial until after the election, and now definitely delaying it after the election. But, what is the point of this? What is this evidentiary hearing going to do, and how is it going to affect? I know you're not a criminal expert, but what were the justices here trying to make happen in this case that hasn't already happened?
So, so the sympathetic view to, if you think the majority is actually in good faith trying to sort of interpret the Constitution as they understand it.
Yeah, let's try. Let's try.
I will say that for Roberts and the other members of the conservative majority, this is not a newfound concern that they've just invented to benefit Donald Trump, right? This dates back to some 50 years of conservative arguments about executive power. Lots of conservatives are still aggrieved. They think that Richard Nixon got railroaded, right? Lots of them think that Ronald Reagan was getting railroaded in the Iran-Contra investigation, and they thought that Congress and the courts were going too far in impinging on the sphere of sort of unilateral executive authority under the Constitution. So those are very deep-seated constitutional beliefs for many of these conservative judges. And so one of the things that Chief Justice Roberts said in the opinion is, and this is true, I mean, this part is true, is that the proceedings in this case have been expedited. They have not been expedited as much as Jack Smith wanted them to be, but at the lower court levels and at the Supreme Court level, they were expedited over the sort of normal, regular case process. Everything so far has basically been decided on the law, right? Just sort of purely written legal arguments by Jack Smith and his team and Donald Trump's lawyers. And there has been very little evidentiary record developed yet, right? And so Chief Justice Roberts said, and this is not unusual for the Supreme Court to say, we think the lower court got the law wrong. Here's what we think is the proper understanding of the Constitution. And so the ordinary way to proceed, and the sort of most judicious way to proceed, is to send it back to the lower court for further proceedings that are consistent with what we've said in our opinion today. And so it's the trial judge's job then to hold the follow-up hearings where they would hear witnesses brought by both sides, they hear testimony, and they hear arguments, in this case, so for the various activities that are for the various conduct by President Trump that's referenced in the indictment, like which of these count as purely official acts, 100% committed to the president that the Supreme Court says we can't proceed at all on, which of them count as these sort of official acts but shared powers, and which of them count as unofficial acts, and we need to have arguments about that. And so that could be, we don't know how Judge Chutkan's going to do it, but that could be an actual sort of full-fledged hearing with extensive witnesses that takes multiple days, and that could, even though Trump's actual criminal trial would still be some months off, it could have some benefit in sort of drawing additional public attention to the facts of Trump's egregious actions leading up to January 6th. Yeah.
Yeah, and we're taping this 10, 11, or 15 days after when the rulings came down, and we still don't know the answer of that. I mean, and part of that is because I was still dealing with the primary and you were on vacation, and so we don't know how exactly this is going to affect the trial yet. There hasn't been any motions yet. The Judge Chutkan hasn't made up her mind, ordered the evidentiary hearing that a lot of people expect. But another judge today decided to at least in part and although I don't know she actually cited it in her ruling, but Judge Thomas or Justice Thomas in a concurrence went farther than the conservative majority, which is no surprise, but he actually opined that he felt that the special counsel was unconstitutional. Now the majority did not find that, and they're allowing Jack Smith to go forward with the insurrection case, or at least so far. But now Judge Cannon in the classified documents case down in Florida, she announced today a ruling that even despite precedent, despite other cases that have gone all the way up to the Supreme Court that have said that the special counsel is allowed, that it's not, and has thrown out the case in its entirety. And many people believe that this is directly because of Justice Thomas's concurrence. And do you subscribe to that?
Yeah, I mean, I think Judge Cannon has probably been working on it for more than 14 days. But I think Justice Thomas's concurrence in Trump versus United States on July 1st sort of gave her a bit of a roadmap and what do I want to say, like sort of a permission structure, right? It's a concurring opinion that's only for one justice. It doesn't have any status as controlling law, but it signals that on the Supreme Court there's at least some support for this argument, and so it may, we don't know, but it may have made Judge Cannon sort of more willing to go ahead with it. You know, she's like, I know I got at least one justice who agrees with me on this. But as you just summarized, it's a pretty striking sort of departure. I mean, I'll just give a sort of quick summary of kind of from Watergate to today. So, of course, one of the big kind of dilemmas that emerged out of Watergate is when there's criminal activity or alleged criminal activity at the highest reaches of the executive branch, then how is it that we're supposed to conduct a credible criminal investigation of that activity? Because, of course, the Justice Department is headed by the Attorney General, who's appointed by the president and can be fired by the president, right? And so it creates a real dilemma for credible criminal investigation. And the solution that was developed during Watergate was that the Attorney General would appoint somebody that they called a special prosecutor, and it would be and the Attorney General said existing statutes governing the powers of the Attorney General and the structure of the Justice Department gave him enough authority to do this, and the special counsel would report directly to the Attorney General, but would have a sort of layer of insulation from the president. You know, the appointing regulations would say, you know, here's what you're instructed to investigate and take this wherever it leads. And you can only be fired like for cause, right? If you abuse your powers or something like that, right? And of course, Nixon famously, after the subpoena for the White House recordings, Nixon famously called the Attorney General in and ordered him to fire the special counsel. The Attorney General said no and resigned. So Nixon called in the Deputy Attorney General and ordered him to fire the special counsel, and he said no and resigned. So Nixon called in the number 3 guy, who was Solicitor General Robert Bork, and Bork fired the special counsel, but there was a public outcry, and Nixon backed down, and they appointed a new special counsel who continued the investigation. So after Watergate, Congress passed a law in 1978 sort of formalizing this process and creating sort of detailed statutory procedures and support for doing basically the same thing. But jump forward to the Clinton era, and independent counsel Kenneth Starr, you know, launched a, you know, sort of never-ending, you know, $50 million investigation of Bill Clinton's extramarital affairs and the like, and was widely perceived, which led to the impeachment and then a Senate acquittal of Bill Clinton. But it was widely perceived as sort of overreach and abuse of power and the like. And so Congress then let that independent counsel statute expire. They didn't reauthorize it because people were mad about Starr's investigation. And so since then, attorney generals from administrations of both parties have returned to the Watergate era precedent, which is just that under existing sort of broad general grants of authority of power to the Attorney General, the Attorney General can appoint a special prosecutor when it's necessary to investigate conduct in the highest reaches of the executive branch. And so that's what Attorney General Merrick Garland did. That's what, under Trump, when Trump's deputy attorney general, Jeff Sessions, was recused and Trump's deputy attorney general appointed a special counsel, Robert Mueller, right, to investigate Trump's own activity. Of course, that didn't lead to any holding Trump himself accountable, but it led to multiple criminal indictments and convictions and jail sentences, right? Multiple people served jail time as a result of prosecutions and indictments brought by special counsel Mueller, and nobody said that was unconstitutional, right? And the courts, affirmed all those convictions. And so Judge Cannon is now saying, yep, but the appointment of Jack Smith and presumably all other special counsels without express congressional authorization is unconstitutional. Therefore, Jack Smith's indictment is dismissed. That argument, as you mentioned, is directly drawn from Justice Thomas's concurring opinion from 2 weeks ago. It's quite sharply inconsistent with existing law. It is.
I got a question for you.
Yeah, go ahead.
On that though, we've talked about how, since the independent counsel statute expired, since then, have there been cases that have risen to the Supreme Court level or even the appellate level that have affirmed the Department of Justice's ability to appoint special counsels in any other case, or that's not been tried yet?
So not the Supreme Court, and I would have to look it up for lower courts, here's my hunch. So anybody who is indicted and prosecuted, right, their lawyers have an incentive to try all available arguments that might work, right? And so my hunch is that at least some of the people who got indicted by special counsel Mueller, right, at least floated this argument and got shot down by the trial judges overseeing their cases and didn't try to appeal on that ground because it didn't seem like it had much legs, right? That's my hunch. What Judge Cannon says in today's opinion is, of course, there's lots of prior federal criminal convictions that were successfully brought by special counsels, including in the Watergate investigation itself. But she says, and the Supreme Court in the Watergate tapes case references and doesn't raise any questions about the special counsel who brought all these indictments and issued these subpoenas that Nixon was trying to resist. But she said what Judge Cannon said today, which I think is at least partly true and might be all the way true, is that in none of these prior cases did the courts explicitly address this particular constitutional question of whether appointing a special counsel in this way violates the separation of powers. And so she says she's like writing on fresh ground, like she's not going against precedent. They've never really directly addressed this question before. To the extent that that's true, it's because all prior courts have just assumed it was constitutional and allowed, and so they didn't directly address it. She literally quotes, Special Counsel Smith relies on 4 different federal statutes, all of which give like some broad authority to the Attorney General. And she literally quotes a passage from U.S. versus Nixon, that's the Watergate tapes case, that references and cites all 4 of those statutes, right? So obviously Jack Smith knew what he was doing, right? The 4 statutes he relied on are the same 4 that were mentioned in the unanimous Watergate tapes decision. But she says, yeah, they mentioned them and they cited them, but they didn't address that argument directly, and so their holding in that case is not binding on me. If the special counsel appeals this, there's a very good chance it gets overturned by the 11th Circuit, which has overturned Judge Cannon previously on other issues. But I do think it's dicey for him to figure out what to do, because eventually Trump can appeal it to the current Supreme Court, right? And I think there is reasonable grounds to believe that they might agree with him on this point. We know Justice Thomas agrees with him, and I think there
agrees
is.
with Judge Cannon.
Yeah, exactly, and Trump and his lawyers.
Oh,
Yeah.
I see.
So yeah,
Okay, yeah.
yeah,
But
yeah, and
I
so.
mean, before we started recording, the special counsel Jack Smith did announce that he is appealing it.
Oh,
So
I hadn't seen that yet. Okay, great.
yes,
Okay.
yeah, no, he did announce that he's going to appeal it. Do you think that this, again, you're not a criminal attorney, but do you think that this is grounds for removal of Eileen Cannon as the judge in this case? I mean, is this as a, assuming that the Supreme Court does keep the special counsel, in doesn't overturn the precedent that they set with the Watergate um, decision. Let's assume that they
So,
keep it. We shouldn't, but let's assume they keep special counsel. Do you think this is would be enough for Judge or Jack Smith to ask for a recusal of Eileen Cannon on
so
the case
poten-
itself?
so potentially, right? So the bar for that is very high. It's very hard to get a trial judge removed from a case against their will, and it's risky to ask for it, because if you ask for it and lose, then you're still stuck with the same judge, and you've made them even madder. Although at this point, I think the downside for
Yeah,
special
what's
counsel
to lose
Smith is
there, right? I
right.
mean,
Yeah,
yeah,
yeah.
it's pretty bad.
So I think the sequence of how it's likely to play out is right. So you mentioned that Smith has announced that he's going to appeal. So that appeal, will take some time for them to write it, and it'll go to the 11th Circuit. And one of the things that they will have to decide is in that appeal, Smith and his team have to decide whether in that appeal they want to ask for Judge Cannon to be removed from the case, right? And the 11th Circuit has the authority to do that. It's just very rarely used. It's a very high bar, and so we don't know which judges will get assigned from the 11th Circuit. We don't know what they would think of that. I think it's very likely that they would reverse Cannon's decision, throwing out the whole indictment on the grounds that the independent counsel was unlawfully appointed. I think it's very likely they would reverse that, but I don't know how to confidently predict whether they would remove her from the case. They would have the authority to do it, right? The way it would work is they would reverse the decision, they would vacate it, and then they would remand the case to a different trial judge because they have decided that her conduct in the case exhibits a clear pattern of bias or something. At that point, Trump and his lawyers could appeal the decision to the Supreme Court, right? And so if what they would probably be appealing is not the recusal part, they would be appealing the substantive ruling. And so then that would delay it further, and it wouldn't go back to any trial judge, right? Then it would be at the Supreme Court. And if they ruled in his favor and dismissed the indictment, then it's moot. It doesn't matter. It's not going back to any trial judge. If they ruled against him on the substantive argument, which I think is possible, then it would go back to the 11th Circuit, and it would be up to them which judge to send it to. So there's a lot of speculation there. It's hard to know how it'll play out. It's hard to know even exactly what Jack Smith will ask for. And all of this, of course, is going to take months and months and months, Yeah.
And there's a little election going on in that time period, and theoretically now, especially with the immunity case that is coming up, or the immunity case ruling, immunity ruling that happened on the January 6th case, if Trump were to win the election on January 21st, he could tell whoever his AG is to drop the charges. That would be an official act that would not be prosecutable, and they would have to drop the charges. And also there's that federal statute about how a criminal trial for the president can't go forward anyways, right? I mean, so
right. And I do just want to nuance one thing there.
yeah.
It's like even before the Supreme Court's immunity ruling 2 weeks ago, it was already very clear that Trump could do that, right? The immunity ruling is bad and it's important, but it's also very easy to kind of inflate its importance even more, right? There's lots of things that there's lots of ways that presidents of both parties have sometimes abused their powers, and not very many of them is like criminal prosecution the most relevant potential check on their actions, right? So presidents have always been able to order the Justice Department to dismiss an indictment. They're not supposed to do it. They're supposed to leave the Justice Department independent, but that's not something that would ordinarily be addressed by the criminal law. And so it's the particularly like egregious and unusual actions of President Trump up to and including January 6th, right, where he's literally kind of as a candidate for office himself, he's trying to use his powers to overturn the results of the election. That's as clear as an example of you're ever going to see of criminal activity by the sitting president that should be prosecuted. For other crazy stuff that Trump did while in office, ideally the checks are, Congress and the courts just interpreting and applying the law, adopting laws that make sense and applying them in a neutral manner and trying to prevent Trump from abusing them. But criminal prosecution, it was always only going to be criminal prosecution of a former president was always only going to be a very rare circumstance. But yes, if Trump wins the election, all of the federal indictments he can just order dismissed. The state indictments in New York and New Jersey, he can probably get federal courts to order them suspended, right, for the remainder of his time in office. And so, yeah, if he wins the ball game right now, the courts are doing lots of scary and dangerous and stuff that's undermining our constitutional system of checks and balances and the rule of law, and all that's super important, and we should stay focused on it and watchdog them and encourage Biden administration to push back, all of that. But the ball game right now is the election, right? Because if Trump wins the election, then there's no prospect of imposing any accountability on him or any reliable checks on him. I mean, again, still just who controls Congress, et cetera. There's all kinds of other variables in play, but the big ball game is the presidential election right now.
So, I mean, we've spent a lot of time on this, and it was one of the more important rulings. But I think, I don't want to lose sight of some 3 other rulings that this court did at the end. The, the Chevron case, the Mifel-Pristun case, and the Idaho abortion law case. So why don't we tackle those in this order? With the Chevron case, obviously another drastic ruling that overturned precedent, even though they didn't quite say that in their.
Oh no, they said it. They
said
they said we're directly overturning Chevron.
Yeah. Oh, they did on this one. Okay.
There's been several prior decisions where they were sort of chipping away. This is what they did with Roe versus Wade too. Like a long history of decisions sort of chipping away at it, and then eventually they directly overturn it. And so, so this one, I'll try to be briefer on these ones, but this is again something that conservative lawyers and judges have been pushing for a long time. Chevron deference is the legal phrase. It's from a case called Chevron versus NRDC from 1984, which at the time was supported by conservative judges, right? And remember, this is the Reagan era. And from the perspective of conservative judges in the Reagan era, right, it was Reagan's first term. He had started appointing a bunch of judges. And of course, Nixon and Ford had appointed a bunch of judges, but Carter had also appointed a bunch of, liberal Democratic judges on the lower courts for 4 years. The federal judiciary was pretty mixed, and if anything, still a little bit left-leaning, certainly as compared to the Reagan administration. And so in the area of regulatory law, there were frequent conflicts where Reagan's appointees at executive agencies were trying to sort of scale back governmental regulatory efforts, right? So environmental laws, labor laws, consumer laws, et cetera. And federal judges were pushing back, right? And so what the court, including conservative justices at the time, said is, so just like quick primer on how the sort of modern administrative state works, right? Ever since the New Deal, right? Congress has been, it's been clear to Congress that we don't have the capacity or the expertise to sort of legislate all of the details of every aspect of federal regulatory law. So instead, what Congress does is they pass a broad statute laying out some general principles, and then they create and empower an administrative agency that is staffed with experts, scientists and the like, who know how to fill in the details, right? So, for example, Congress passes the Clean Water Act that says it's illegal to pollute the nation's waterways, right, in ways that are harmful to human health. And then scientists at the EPA are directed to periodically draft and review and update particular standards, like how much mercury, how many parts per million of mercury can be in a river before it's dangerous, right? Congress doesn't know the answer to that question, and the answer to that question changes with new scientific investigations over time. So they delegate that authority to the administrative agencies. So here's the thing: legal conflicts regularly emerge where an agency issues regulations and the person or corporation who's subject to those regulations say, oh, the agency has gone beyond the authority that was in the congressional statute, right? Congress didn't authorize them to do this. And you got to look at the statute, and sometimes there's a clear answer, and sometimes the statute's kind of ambiguous because Congress wrote general principles and they didn't anticipate this specific question. So Chevron in 1984 says, if the law is ambiguous, the law passed by Congress, if it's clear, then that tells us what to do. But if the law is ambiguous, then we should defer to any reasonable regulation adopted by the agency, right? If the law is ambiguous, right, and the agency says in our expert judgment, here's what we think the rule is, as long as it's not completely unreasonable, it might not be the one we would have adopted, but as long as it's a reasonable interpretation of the ambiguous law, the agency experts should get the benefit of the doubt because they, A, have the expertise, and B, are politically accountable, right? Because they appoint to agency heads who are appointed by the president, who's elected by the people. That's Chevron deference. The court reversed that this year in the Loper-Bright case in late June, and they say no. It's always up to federal judges to say what the law is. So the agency regulations get no deference. And so now, of course, the political dynamics are different than they were during the Reagan era. Now we have a very right-leaning federal judiciary. And whenever we have a Democratic administration, like currently, we have agencies that are trying to adopt aggressive sort of liberal, regulations of corporate malfeasance and the like. And so this conservative judges have been pushing for this for years. They finally got the votes. It is going to have a dramatic impact on federal regulatory law, although I think it's a little bit hard to game out because I don't know that the conservative judges have fully thought through like what they've bitten off. There's going to be like endless litigation that is going to seriously test the capacity of federal courts unless they come up with some new rules to streamline it, right? It's like every corporation that's subject to federal regulations has like this new case to cite, and they're going to challenge every regulation that applies to them. And I don't know what the federal courts are going to do with all that. But the answer is there's going to be a lot more federal judicial decisions striking down environmental and labor and consumer safety regulations.
Right, and that's the goal, right? I mean, that's what the conservative ideology wants, is to not only to strike down these laws, but to jam up the courts and backlog it so the decisions become moot because it stayed over time, and you can't, now we're going to be arguing every scientific decision inside of the court.
And let me say just one more thing about this case, and then we can talk about the other ones. But this case, together with the Trump versus U.S. immunity decision, is really troubling because they're both about executive power. They're about two different kinds of executive power. Trump versus U.S. is about the president's own specific powers and immunities. And the Loper-Bright case is about the powers of executive branch agencies like the EPA or OSHA. But if you take them together, it's a really troubling juxtaposition, right? The shorthand for it is like strong man, weak state, right? Like, what kind of way is this to run a democracy where we are intentionally hamstringing the sort of independent sort of policy apparatus of the federal government while giving greater unreviewable unilateral authority to the single person at the head of that government? It's a real recipe. If you look at sort of in comparative terms, like Hungary, Brazil, Turkey, and the like, it's a real recipe for sort of autocratic breakdowns and checks and balances. So that's the last thing I'll say about that one.
Yeah, no, and I do want to move on to, I guess, some would call them as victories. I do not, but I see them more as punts. But the mifepristone case and the Idaho abortion care law case, where both the Supreme Court, in essence, well, in the Idaho case they ruled on standing, and in the mifepristone case they pretty much said, well, we shouldn't have taken this case, right? Or both of them were like that, where they said, oh, we shouldn't have taken this case. And no, it was the mifepristone case that they ruled on standing. I'm sorry. And the Idaho case where they basically said, well, we shouldn't have taken this case in the first place. So back to the courts and we'll deal with this later.
That's right.
But,
And here's the best way to understand those
yeah.
cases is that so no matter how far the Supreme Court moves in one direction or another, right? So this would be true if the court, was moving sharply left as well. So no matter how far right the current court moves, the equilibrium is always going to be a mix of liberal and conservative decisions. And here's why. And equilibrium is kind of political science jargon for like the sort of stable state of affairs that kind of emerges and takes shape and then kind of holds. The equilibrium will always be a mix of liberal and conservative decisions. Sounds counterintuitive, no matter how far rightward or leftward the court moves. And here's why. Because as the court moves further rightward, conservative lawyers and conservative lower court judges get more aggressive, right? Mifepristone has been approved by the FDA for decades, right? It's been in use for early term abortions for decades, but conservative lawyers who are opposed to abortion and conservative lower court judges, especially in the Fifth Circuit, are like, oh, wait a minute, but look, we got this new court. It's moved really sharply rightward. Maybe we can get them to, issue a very aggressive decision, reversing the FDA's, decades-long approval of mifepristone. And so they bring like a very aggressive case, and the lawyers bring a very aggressive case, and some lower court judges are cool with it, and they endorse the very aggressive case. And they have gone too far for the current Supreme Court, right? And the current Supreme Court, either because they're not quite as conservative as the Fifth Circuit, or because they're still trying to move a little more cautiously and incrementally on some circumstances, or they're just worried about issuing 20 landmark conservative rulings all at once, it goes too far. And so it's like a liberal decision in the sense of they rejected these conservative arguments, but the arguments that they rejected were extremely aggressive efforts to move the law in a conservative direction. And so that there will always continue to be some liberal results, some unanimous decisions, some liberal results, etc., because the mix of cases shifts when the court shifts, right? And so some of the advocates are going to overshoot, right? They're like, well, we got the court to reverse Roe versus Wade. Now let's get them to do this next aggressive thing. And the court's like, nope, slow down. We're not ready for that one. So it does not signal necessarily any degree of like moderation by the court. It's just a sign of the sort of shifting aggressiveness of the cases. Another good example of that from this term is the gun rights case about the federal law saying that people currently subject to a domestic violence restraining order may not lawfully possess firearms. And the Fifth Circuit declared that law unconstitutional, citing Justice Thomas's opinion from the New York case from 2 years ago. And the Supreme Court reversed that decision. Justice Thomas was the only one. It was 8-1. Justice Thomas was the only one who would side with the Fifth Circuit on that. And that doesn't mean the court doesn't believe in gun rights anymore. It just meant some of the lawyers and judges pushed it too far, too fast, right? And so that's a liberal result. I'm glad they didn't overturn that law. It's a correct legal result. And it's a legal result that I personally agree with, but it's not really a sign of moderation. It's just a sign that this is a very, very aggressive conservative claim that was brought. So yeah, same deal there.
Yeah, and I think, unfortunately, my view is that you said too far, too fast. I think it's too fast. Like, I think that's where we're going with both these cases. If a if Trump is returned to the White
If,
House,
if Trump wins, then he appoints some more justices. Yeah, the
yeah,
court moves even further, for sure, for sure.
or even like, again, the Idaho case can come right back to the Supreme Court because all they did was remand that back to right back to the Iowa courts to wait for a final version because they put a stay on, or they issued a stay on that when they shouldn't have. And so they can still rule on that. And the Mifepristone case was about standing. Well, there's other cases where instead of these wacky dentists and other doctors that were part of this, there's state actors that are working on this, and they will probably have standing, so then they'll have to rule on the merits, and we don't know how they're going to rule on the merits because they haven't talked about the merits on the cases. So it's I do think that unfortunately we haven't heard the last of either one of these cases, or at least these concepts coming back next year, or in years to come. So, Professor Keck, is there any other case before we wrap up? This will be my what haven't we talked about, but is there any other cases that maybe we haven't talked about?
I'll just flag one because I remember
Okay.
I mentioned them in April. And so that's the cases about free speech and social media,
Right.
right? And so, one of the crazy making things about this court is like literally on the same day that they issued the quite extreme law altering, right, and very Trump benefiting decision on immunity in Trump versus United States, on the very same day, like literally like 20 minutes earlier, right, just right before it, they issued a very kind of normal and like sort of quasi unanimous. It was unanimous in the result, although they were divided 6-3 underneath, but with 6-3 with the three most conservatives in dissent, right, with the liberals and some of the conservatives together. Like and just a case on free speech on social media, and like if you read it, it's like reads like a normal Supreme Court opinion. There's very difficult competing considerations in trying to decide whether and how states can sort of force social media platforms to either allow or not allow certain content. Um, there's challenging questions there. I think the case came out in the right direction. The social media companies won that case, although it's just sort of a provisional decision. It goes back to the lower courts. I think the lower courts will now eventually strike down these recent laws enacted by Florida and Texas, trying to tell the social media companies what to do. I think that's the right decision, but I also think there's trade-offs, and it does a nice job of discussing those nuances. And it's like, it's very firmly rooted in existing precedent, even though it's addressing a new question. And it's like, that's how the court's supposed to operate. And it's liberal and conservative justices together in that majority opinion. And like on the same day, they issue this highly polarized 6-3 opinion protecting Trump from criminal prosecution. And so that's just one of the sort of, crazy making sort of idiosyncrasies of this current Supreme Court. Like sometimes they look like they're trying to act like judges, but quite frequently they look like they're acting in a sort of partisan or ideological fashion.
Well, Professor Keck, thank you so much for coming on once again and spending an hour with us and walking us through the various twists and turns of this hyper-partisan, hyper-conservative Supreme Court. One of the things that I'm sure, and I hope we'll be talking about later on, early next year, if President Biden is reelected, is that he has promised some major Supreme Court reforms that they're going to roll out at the Democratic convention. I guess we'll see. Why wait? But I guess they're promising some major reforms, and I think it's probably because of some of these rulings that we've seen, and of course the culture of corruption with Justice Thomas and Justice Alito with their travel agencies by right wing billionaires. But
Yeah, I'm happy to come back and talk about those
we'll
things
talk about
when
those
they
in
happen.
January.
Yeah, yeah.
Thank you again, Professor Keck, and enjoy. And that was my interview with Professor Thomas Keck. Always a pleasure. Just such a bunch of knowledge that he drops on us each and every week. This week, Commissioner Carr on Tuesday, I'll be talking about the Partnership for Large Election Jurisdictions Conference that I just finished attending today. Lots of great stuff to talk to you about. Weekly Wonk this weekend will be about the primary election, finishing that up, talking about election day and overall turnout. This last weekend, I talked about alternative voting, early voting, absentee, vote by mail, and affidavit voting. And then, of course, my Zoom with Czarny next week. That will resume. I'll be talking to Al Sturpey, who is Assemblyman Al Sturpey about, I'm sorry, Assemblywoman Pam Hunter first, and then Assemblyman Al Sturpey. So the next 3 weeks, I'll be back to my interviews of candidates, and that will be really what I'll be doing from now until election day with Zoom with Czarny. The democracy advocates will take a break, and we'll be back. We're talking to the candidates, starting with next week with Assemblywoman Pam Hunter, then Assemblyman Al Sturpey the week after, and county legislator and state senate candidate Chris Ryan the week after that, and then more to come. So check it all out at dustinczarny.com. You can subscribe and get notifications anytime I do content or election news updates. Thank you again for tuning in, and enjoy your day. Bye-bye.